Andy McCarthy joins us now from Chicago. If I remember correctly, his son is a catcher for the University of Chicago. They are playing right now up at the White Sox field. That is pretty awesome. I'm sure that was fun to watch as a dad. Congrats, Andy. Let's dive into this chaos. New York Times publishes an editorial. I don't know if you've had time to see it, basically saying the entire concept of this Trump trial is garbage. Credit to the New York Times editorial page for publishing it. It's a Boston University professor in the law school there who wrote it. Has anything that you have seen in the first 2.5 days, 3 days of the trial changed your mind about the legitimacy of this case? And if so, or is it even more convinced you that it's garbage?
Yeah, it's more convinced me it's garbage, Clay. I think now that we're looking at it really closely, I'm not saying I hadn't looked at it closely by now, but like the insidiousness of this was not as apparent as it's become. To put it in a nutshell for people, you're supposed to, if you indict somebody, the charges have to be in the indictment. That's a constitutional requirement of the Fifth Amendment. What Bragg indicted Trump for was falsification of business records with criminal intent. At the same time he filed the indictment, he filed his own statement of facts, or what he purports to be facts. Now, that in and of itself is peculiar, because usually what prosecutors and grand juries do is in the indictment itself, the grand jury alleges the narrative in which the various criminal offenses are alleged to have taken place. That's not what Bragg did here. He had the grand jury return a bare bones indictment, essentially just stating the statutory offense without any color or description. Then he files his own statement, which is not the grand jury statement, in which he says the crime is that Trump conspired, or actually he uses the word schemed to steal the 2016 election by suppressing politically damaging information, which is not what the grand jury says. Then they get to trial, and the ante gets up, so now they're not using the word scheme, they're using the word conspiracy. And the problem with this is, aside from the fact that it's not in the indictment, there's no such crime as conspiracy to steal an election or conspiracy to suppress politically damaging information. A conspiracy is an agreement by two or more people to commit a statutory crime, like bank robbery or murder or the like. There is no crime, and Trump isn't charged with it in the indictment. So the whole thing is just ridiculous from Jump Street.
Andy, who can in the system do something about this? Like, what are the ways in which someone on either on appeal or on some kind of an emergency motion, like, how can this crazy train be stopped?
The only thing I could think of, Buck, would be, and I don't think this would work, like an emergency application to federal court saying that Trump's constitutional rights are being violated. And I think what the federal court would probably say is, we're not going to intervene at this point. We'll wait to see what happens in the case, because if he gets acquitted, there'll be no reason to do anything. And if he gets convicted, he'll have his full array of, appellate rights. Plus, that court hasn't been friendly to him anyhow. So I'm not sure they'd be tripping over themselves to intervene here. But they really should, because what's happening here is pretty outrageous. I mean, the other thing to note is that the way that Bragg inflated this misdemeanor falsification of business records, on which the statute of limitations would have run in 2019, because the alleged crimes were in 2017. The way he does it is he says that the falsification of records was done to conceal or commit another crime. And it turns out the crime, which he hid this from the grand jury too, the crime he's talking about is federal campaign finance violations. And I think one of the things we haven't noticed, but we should start noticing, is that this is a clear episode. Well, it's not clear, but it's an episode of collusion between the Biden administration, the Biden Justice Department, and brag. And the reason I say that is, it's easy enough when we're talking about Jack Smith to see that there's a relationship between the special counsel, the Biden Justice Department, and Biden. Jack Smith exercises Biden's executive power, and he answers to Merrick Garland. So that's easy enough to see. But here, it's a state prosecution, so it's not easy to see. But the fact is, if you look at the Justice Department guidelines and the Federal Election Commission guidelines, what they say is that those two agencies are the exclusive authorities in law for enforcing federal campaign finance law in connections with elections for federal office. So if anyone else other than Trump were the person in the trick bag here, and a local prosecutor somewhere in the United States tried to enforce federal campaign law, the Justice Department and the FEC would ordinarily go crazy. They would not tolerate it. They'd be in court trying to stop it. It just wouldn't happen. But here, they haven't made a peep. And the only reason that makes sense that they haven't made a peep is that it's Trump.
I also think this ties in, and you'll be able to explain this better than I could. We talked earlier this week about the prosecutor who made the opening case, Matthew Colangelo. He had risen to third overall in the Department of Justice. I think we talked about this with Kash Patel Monday maybe or Tuesday on the show. You were a prosecutor. Have you ever seen somebody from this high in the Department of Justice leave the Department of Justice to prosecute a state crime? The analogy I made, you're at a ballpark up there in Chicago, would be this is a little bit like somebody who's in the major leagues going back down to single A or double A ball. If you have the political power that you would that high up in the Department of Justice over all federal charges, to go and then do a state prosecution, it's kind of unheard of, right? Which to me is evidence of how enmeshed the Biden administration really is, even in this Alvin Bragg case.
Yeah, it's highly unusual. Now, to be fair, a couple of things. I don't know what Colangelo's status was there. Like, I don't know if he thought that they had their eyes on moving him out and moving somebody else in. And sometimes when people have political ambitions rather than just prosecutorial ambitions, a seemingly lateral move or even a move down can be something that helps your political career. So, for example, Rudy Giuliani was the number 3 guy in the Reagan Justice Department, but he asked instead to become the U.S. Attorney in the Southern District of New York. And even though a lot of people in Washington may have thought that was a crazy move, for someone who was politically ambitious and wanted to be mayor of New York, it made perfect sense. And he became a much more famous and effective figure as the U.S. Attorney in New York than he would have been as the number 3 guy in Reagan's Justice Department. So there's a lot that goes into it. But to leave a position like that to try a single case would be highly, highly unusual, although you and I both know that, whatever Democratic prosecutor nails Trump is going to be, he's going to be an icon for these guys.
So, Andy, this brings us back to where this is all heading, it seems, right now, and also the gag order. Can you tell us about how you're viewing that component of it? Because there's been a lot of back and forth between Trump already and the judge, and they're saying, he's saying things about witnesses he's not allowed to say. It just feels like what are the limits of this gag order? Can you just weigh in on that component?
Yeah, well, I've had a big problem with the gag orders from the beginning, Buck, not just this one, but also the one Judge Chutkan issued in Washington. And the reason is I think these arrogant judges, and these are the Democratic judges. I don't think Aileen Cannon has done this down in Florida. But I think these arrogant judges won't accept the fact that in this system, every right and every duty has to coexist with other rights and duties with which it's intentioned. And sometimes, even though the administration of justice in a case is a very important public interest, there are higher public interests than that. So robust political debate in connection with an election for the highest office in the country is a high constitutional interest. Trump has a constitutional right to run for the presidency. So even if in a normal case you would crack down on what parties could say for fear of influencing the jury pool or intimidating witnesses or what have you, here the interest in the administration of justice has to yield to some extent to these other more important interests. And these judges won't do it. And the fact that they keep saying the administration of justice has to be exalted overall, otherwise Trump is, somehow above the law, is ridiculous. If they were that interested in the administration of justice, they could put the trials off until after the campaign is over. And then nobody could argue that the administration of justice was the higher interest at that point. But they won't do that, of course, because the prosecutors, who they're working in cahoots with, it seems, want these trials to take place prior to the election. So it's like they create the crisis that puts the administration of justice in tension with these other more important constitutional issues. And then they say, Trump is the one who has to yield, as if like a court doesn't have to ever bend to some more important interest. So that's what's happening here. And I actually think, given that Trump is running for president, which he's entitled to do, and giving the public interest in robust debate in a presidential campaign, Trump should not be gagged except to the extent that the law already essentially limits what people can say. So, for example, if Trump makes a comment that amounts to incitement or obstruction of justice, he can be prosecuted for that. If he says something that defames someone, he can be sued for that. If he says something that helps the prosecutor's case, they can use it against him in the trial. So he's got a lot of incentives not to say stupid things, and there's a lot of downside for him in saying stupid things. But he shouldn't be gagged ahead of time and told what he can say and what he can't say under circumstances where every witness is allowed to talk about him, and every political candidate, including Biden, can say whatever they want about the lawfare against Trump, and he's not allowed to respond. That's crazy.
Last question for you here, Andy. You've picked a lot of juries over your life and been involved in jury selection. I know you haven't set for jury selection, but based on what you have seen, Buck and I both say there's a 0% chance of a not guilty verdict. I bet you would likely say that as well. Do you feel like Trump has any reason for optimism based on the jury was selected, that there might be someone, or maybe more than one person, who are willing to consider a not guilty verdict? Any read from you on this jury?
Yeah, I'd say two things about that, Clay. One is some of that gets evened out. I agree that Manhattan is not great for Trump, to say the least. On the other hand, I wouldn't read too much into Manhattan by the fact that they elect Alvin Bragg as their DA. The people who vote in those elections are, it's tiny compared to what the jury pool is. And I think there's a lot of people in the jury pool who would be sympathetic to Trump. And statistically, what the advantage Trump gets, aside from not having to prove anything, is that he only needs one juror to get a mistrial, whereas Bragg needs all 12 to convict. And the one other thing I would say about it is I think under New York law, Trump is entitled to a lesser included offense instruction, which means he should be able to get the court to instruct the jury that they could find him guilty of the misdemeanor business
sort of a
record
compromise
violation.
verdict is an option, in other words. It's not either or.
Yes, but here, if they were to convict him of that, the statute of limitations ran on that in 2019, so the case would have to get thrown out.
Oh, wow. That's a great point.
Very interesting. Andy, we're going to need you to stick around. I know you got baseball with the son and fun things to do in life, but, it's going to be a long, what have we got, 6-7 months here. So thank you for being with us, Andy McCarthy, and go check out his latest at nationalreview.com, everybody. Thanks, Andy.
All right, guys.
Thanks very much. The work at the Preborn Network of Clinics is so admirable. The dedicated men and women involved are saving the lives of tiny babies every day. They do that by giving an ultrasound experience to pregnant women who are deciding between life and abortion for their unborn baby. They offer this ultrasound so that the mom can meet her unborn child. And that's just one of many resources, though, that pregnant mothers can count on at the preborn centers. Maternity clothes, diapers, baby care items, all are available for those who need it. But it's that ultrasound experience that so often is the decision point for mom to give life to her baby. Because when mom hears that precious heartbeat and sees the baby's movements, the choice so often is made for life. An ultrasound is just $28. Any amount you can donate will help, and all gifts are tax deductible. To donate securely, dial pound 250, say the keyword baby. That's pound 250, say baby, or go to preborn.com/buck. That's preborn.com/BUCK. Sponsored by Preborn.